Hi everyone, so my name's Claire Jacques. I'm Senior Associate at Brookstreet Roches law firm. I specialise in commercial IT law, but I have a particular interest, perhaps one could say geeky interest, although I could be in good company, in relation to cloud computing. And I have noticed actually through the media, through people generally chatting, that cyber and security in the cloud really are buzzwords, and they evoke fear. I felt a bit scared when the presentation was given, the sort of risks we might be exposed to and opportunity in equal measure. And I guess as a lawyer, I guess I'm bringing the legal layer alongside, not separate from, some of the commercial and IT considerations you need to make in this sector. So I'm going to just ask two questions, really. Why is cyber security, why should it be on the radar for your boards in 2016? And if you're going to put data in the cloud, which of course you are, what are the risks and opportunities with that? How do you choose which provider to go with? And how are you going to use the contract to manage those risks rather than just the commercial agreement? Okay, so we'll start with the threat then, the scary stuff. Or if you're going to use the government's language, the threat, because it is now denoted tier 1 threat to national security alongside terrorism. Why is it a tier 1? Because of the scale, because of the impact to all businesses, small and medium. When I read about cyber attacks in the news, obviously what you get is the sensationalist stuff. I don't know if everyone remembers at the end of last year, the alleged attack by the Korean government on Sony Pictures when they were trying to put this film out about the leader. Anonymous, the activists, politically motivated hacking, who are getting a lot of publicity for hacking into so-called Islamic State's website, and Donald Trump as well. And I'm being recorded, so I won't make a political statement about how long they should have kept that website down for. But if we were to take it to home, what's relevant for you, actually the real issues are the criminals, theft, hacking, ransomware was mentioned. When I gave a talk about this a few weeks ago at my law firm, someone told me they'd been a victim of cyber extortion. So it's actually happening to businesses. And then the insider, by that I mean your employees. They may be disgruntled, or maybe they're just untrained. They had a careless lapse, they left the laptop on the train, and there are consequences for that. If I'm thinking about the consequences of a breach, I think I'll bring it to life a bit more for you, give you a specific example. TalkTalk was mentioned before, so I'll tell you specifically what happened to TalkTalk. Their website was hacked into, 157,000 customers had their personal data stolen. It's cost them £60 million and growing in financial costs. And obviously the damage to their reputation has been huge. What are the costs? Well, they had to spend money responding to the incident. There were so many calls to their call centre. The revenue that they lost when their website went down, enhanced security packages that they had. It was a good day for security companies, I think, for TalkTalk's issue. But I think the really key thing about what happened to TalkTalk is they were not prepared. They were slow to respond, and I think that's a really good lesson for us as businesses to learn now. So a legal framework, there is a legal framework, and I certainly feel as a lawyer, the lawyers are limping behind the pace of technological change and what's going on in the dark web. If we start politically, the government are standing behind the fact that they're calling this a tier 1 threat, and I'm not sure if anyone here is familiar with the Cyber Essentials document that was published last year. It's essentially a 10-step guide for small and medium-sized businesses to self-assess the sorts of security standards they have, and I think it's a really good starting point. The Law Society is certainly saying that law firms, that's what we should be benchmarking against. And then from a regulatory point of view, yes, the big cloud, perhaps with the silver lining of the European data protection regulation is looming, but it's not law yet. And who knows what's going to be happening with Brexit. So we are still talking about the Data Protection Act, and in particular, the beautiful Principle 7 having the appropriate technical and organisational measures in place. The question that I would ask, though, is if you're starting to use mobile technology, the Internet of Things, you're putting your data in the cloud and you don't have control anymore, and it becomes much harder to comply with this principle. Now, who is regulating all of this? It's the Information Commissioner's Office, and they're taking what I would call a carrot and stick approach. The carrot being, there's really good information on their website, they produce guidance. So in January of this year, they produced an IT guide. They've also done guides on bring your own device, also for mobile technology and also for cloud computing. But the stick is that they're clamping down. And I had a look on their website this morning just to see the various fines they've given out. And actually, there have been 3 fines in the last 4 months for businesses that have breached data security, the biggest one being Money Shop, a £180,000 fine because somebody lost computer equipment on a train. That's a really expensive mistake. General data protection regulation has been talked about already. I think what I would add with my legal perspective that's different for providers of services, as processors, you actually have a legal obligation to have the technical and organisation measures in place. You can't say I'm only a processor, you're going to be subject to a fine, and I think that's really, really important. The other thing on the EU scale I think it's worth knowing about for anyone who transfers data to the US. At the moment, there is negotiation about putting in place a new, what they're calling Privacy Shield. This is the agreement between the EU and the US of sending personal data to the US. It used to be safe harbour. And the court last year, the European court, said that that was void. So in the wake of the Edward Snowden revelations, essentially, you can't guarantee the US government is not going to get your hands on the data. I had a quick check again this morning to see how they're getting on. And the Article 29 Working Party is basically saying, not doing so well, need to do better, still concerned about mass and indiscriminate surveillance. So there's still stuff going on there, and we'll see what will happen. At the UK level, there is also this discussion about this balance between privacy and national security. I'm sure you may all be familiar with the Snoops Charter, the Draft Investigatory Powers Bill. So that's had its second reading in March, that's passed, and there is a lot of controversy about encryption, about bulk interception and hacking, and again, we'll see where that balance ends up. So what can you do? Is there anything that you can do? And I would certainly advocate you take a coordinated approach across disciplines. So that means you engage your lawyers, but actually you look at it strategically. You speak to comms, so they're prepped if there's a data security breach. You get your IT involved, you get people talking to each other. And then you carry out a risk assessment. What's your critical infrastructure? Where is your sensitive data? Do you understand your regulatory obligations? Have your lawyers been briefing you? Do you know if there's specific standards like PCI DSS if you're holding credit card data? So know your law. Self-help is really important. So check your insurance cover. Does everyone in this room know that you can have separate cyber insurance? They had a talk, there was an article I read last year that said 50% of CEOs thought that they had cyber insurance and 10% of those businesses only actually did. So it might be worth checking who's going to be responsible, do you have insurance if your data gets lost or stolen or your customers does. Also, disaster recovery and business continuity. Have you got backup? And the final point here, and that's going to bring me to the cloud, it isn't really much good that you've got all your cybersecurity measures in place for your own business if you're shipping it to a third party. You've got to use your contract to make sure that they get passed on. So that brings me to my second buzzword then, cloud computing. We can just use it as an umbrella term. It's over the internet, it's on demand, it's scalable, it's all the same thing. Well, of course, it isn't. It's multi-layered. You've got software as a service, platform as a service, infrastructure as a service. And of course, you need to understand the differences between them. And actually, when you're going to be buying the service, does the service offering match your business requirements? And obviously, finding that match is really important commercially before you even start thinking about the legal issues. So certainly some things I would start thinking about when you come to the contract and what you're going to be signing up to is it a public cloud or is it a private cloud? Why does that matter? Because if it's public, it's probably going to be cheaper, but it's going to be a one-to-many model. Your security is going to have a lower level of protection. Is that going to be good enough? Private, you'll pay more, the security will be higher. That's something to think about. Other things I think about when I'm trying to get a sense of the difference between the three, which jurisdictions are your data going to be stored in? Is it going to be outside the EEA, because you've got to comply with that Principle 8 of the Data Protection Act? Third parties, yes, it may be a good idea to have 2, 3, 4, 5 different service providers, but if you check with your cloud provider who sits behind it, peeling away the layers of the onion, and are they on the hook under the contract to comply, or are they not? So I think it's really important to check that. And the final one really is about control. Who has controls over system and security? Because if you don't have control, then who's going to be liable for loss of data? So take it as it is. This is typically what a cloud computing contract would look like. Historically, it was very much like the click-wrap acceptance you might see on the internet. So you just take what you can get. This was because it was a one platform to many model. It was a low subscription fee. Certainly as a provider, low profit, low risk. So as customers, you had no rights. And if you have a look here, these are the sorts of things that you would see in the contract which you couldn't negotiate. But I would say the environment is definitely changing now. You've got a data explosion, you've got cybercrime on the rise, you've got a regulatory climate that's toughening up. And so customers are basically savvier now, or maybe they're just more nervous. So what can you do? Well, certainly you want to negotiate. You want to think what I've talked about, recognizing the different layers of service, thinking about the different risks and issues, regulatory, commercial liability, and you want to talk to the provider about it. And I've certainly seen that the market, the cloud computing market, there's a lot more competition, which gives you more flexibility to negotiate, and the offerings are complex. So you might have a hybrid model, kind of public for some data that's not so sensitive, private that just locks in your really sensitive data. I was just going to pick off a few of these, given I've probably got about 1 minute and 20 seconds left. The very first one, the most important one, is who is liable if your data is lost or stolen or corrupted? You might think the provider is on the hook, but actually, if you're responsible for security, you're going to be the one that's on the hook. Check the contract. Does it exclude liability for loss of data? It's absolutely the first thing that I would check. And then data security. We've talked about it. The provider tells you how fantastic their data security measures are, and they don't get incorporated in the contract. I would include a provision that requires the provider to notify you in the event of security breach. And finally, exit. No one ever talks about exit. But what about your ongoing licenses? What about data migration? You need to put it in the contract. I'll leave you with the checklist then. I've got time to note some of these down. My advice really is you need to peel back the layers so that you get the product that's right for you and you understand the risk. I think it's really important that you negotiate a contract that draws together commercial, technology, and legal. And certainly what we do at BSDR is we coordinate the approach, we draw the strands together, and I think then you get a contract that manages your risks and also reflects your commercial requirements. So that's it for me, and I'm sure I can take questions later if anyone has any.